All right, hi, welcome back, Attorney Steve, and welcome to another exciting episode of Litigation Whiteboard. All right, in this episode, I had a couple requests over the last year or so for enforcing judgments. So you just got the $500,000 judgment. You're a plaintiff, you just got the big judgment, or you're a defendant and someone just got a judgment against you, or you defaulted on a complaint and somebody got a judgment against you. How do they go about enforcing it? Well, what happens? This is a common question I get. So without further ado, let's head to the Attorney Steve Litigation Whiteboard. All right, so you just got the big judgment and you're going like, okay, $500,000, now how do I get paid? I got the judgment, how do I get paid? Or let's say you're the debtor. Okay, so what happens after a judgment? Here's my magical judgment right here, the big J. That's what you're looking for in legal cases. If you're the defendant, that's what you're looking to avoid, the big J. Okay, so it's renewable. This is the big thing about it, is judgments are renewable. Check your states. Every state has its own rules or whatever. Okay, but so what some people will sometimes say, the debtor's over here, let's call him the judgment debtor. Let's call this person the judgment creditor. Those are the proper terms we want to be using, okay? So the creditor wants to get paid. The debtor wants to avoid having to pay. So what are the common methods that are used to enforce a judgment? This is good for everyone to know. Now, I'm going to tell you up front, general legal information only, not legal advice. Also, I don't do judgment enforcement and collection. I don't do all that stuff. So take this with a grain of salt. This is to help a couple people that have asked me what happens. Number one, I want to talk about debtor exam. Okay, first thing you need to know is if someone gets a judgment against you, they can seek from the court what's called a debtor examination. Okay, so this is where they haul you in. They subpoena you in. It's under, if you don't come in, it can be contempt of court. That means you can be held. There can be an arrest warrant, a bench warrant issued for your arrest. So these are real serious. It's not easy to avoid some of these things, but they can file for a debtor exam, bring you in. You can get an attorney. They have an attorney and they start asking a bunch of questions. Where's your bank? What kind of assets do you own? Where's your house? Do you own any real estate? Do you own any assets? Do you have any jewelry? Do you have any fine art? I mean, it goes on and on and on. Do you run a business? How do you have receivables? I mean, do you have accounts receivable? Do you have a boat? Do you have a yacht? Do you have a this, that? I mean, it goes on and on and on. It's all under oath. And what happens here is the judgment creditor can ask you all these questions, and then they can issue subpoenas. They can issue a subpoena to your bank, or they find out, here's a real good one. Nowadays, when you're trying to get a loan, they ask you everything under the sun. This, where's all your property? Where's your bank, your profit and loss, this, that. They ask you a ton of things. So if you come to the debtor examination and you say, well, I just applied for a refinance or a home equity line of credit, they can subpoena those applications which have everything on it. So you may not be telling the whole truth and nothing but the truth here, but though it will lead to other things that can be subpoenaed, and eventually they can track down and figure out all your assets. So number one is just realize if you default on a lawsuit, okay, some people will ask, well, what happens if I default? This is probably going to be in your future, a debtor examination. Next. This is another important one. If you have a job, okay, a wage earner, let's say you're a wage earner, you have a boss and a company you work for, your wages can be garnished. Now, every state's going to have different rules. Maybe it goes up to 10, 15, maybe even 25% of your paycheck. So you want to make sure you understand that before, because here's another thing that happens. You're trying to keep everything secret from your employer. And next thing you know, they're getting a notice of garnishment, wage garnishment, and now they find out and they say, well, what's going on here? What's this notice of wage garnishment? Did you do something wrong? Well, oh yeah, then you have to explain. It could be embarrassing. So wage garnishment. Now, if you're self-employed, it's gonna be a lot harder. Okay, but it's garnished through your employer. That's a wage garnishment. Next, I have Whoa, WOE, a writ of execution. Okay, this is where you go to court and say, Judge, I know we got a lot of things here. He's got a boat, he's got a car, he's got a bank account, he's got a business with all these assets and all this money that's due and inventory and all that. I want a writ of execution. A writ is like an order from the court. The writ of execution you can give to a sheriff in your county and they will levy, or you can send it to the bank. The bank will levy. Say you got $100,000 in the bank, they have a $500,000 judgment, they get a writ of execution and they serve it on Bank of America or Wells Fargo. Bye-bye money, bye-bye, zip zap out of the account just like that. Attach your receivables, levy those. They can gather it and they can sell it at foreclosure sales. They can sell it at sheriff sales, things like that. And any personal property, boats, trains, planes, automobiles, helicopters, whatever you have. Writ of execution, obviously a big one. Finally here I have a lien. This is on your real property. Abstract of judgment, AOJ, abstract of judgment. What's that? It's basically a lien that you file when you have a debtor, okay? You figure out where they own real property. You do the debtor exam, let's say, or you know through discovery or whatnot. You put a lien on their property in every county where they own property. They may own a lot of land in San Francisco, California. They may own a vacation home in San Diego. They may own 2 houses in Newport Beach, 2 rentals, whatever. You can put a lien with the county recorder. It's called an abstract of judgment. Check your state, may be called something different, I don't know. And you will have certain homestead protections, which will protect certain amounts of your equity. Check your state. Every state's going to be different. But it's a lien, and so what happens? People go, I don't care. They got a lien on my house, but they don't have my money. Well, what happens when you go to sell your house or refinance or seek cash out? All of a sudden, they say, well, your mortgage officer says, hold on, there's a lien you have to pay here. You say, what? Yeah, it's that $500,000 judgment that was entered against you 6 years ago. And you go, oh, jeez. Yeah, okay. So that's how abstracts of judgment work. So see, these are some of the common enforcement tools that you will see. 2 more notes real quick. I have BK, okay? So sometimes you can look at bankrupting a judgment, okay? Because a judgment is typically not a secured creditor. They don't become secured creditors. They're unsecured creditors. All they have is a piece of paper with a big J on it, okay? So they're unsecured creditors. So there may be times if you have absolutely no assets that you want to file like a bankruptcy chapter 7, let's say. That's what we call the no asset. You have certain, I'm not going to go into it here, but there's a 7, there's a 13. That's for if you're making enough money over a certain median. It's repaying over a couple years, 3 to 5 years. And you have business bankruptcies, chapters 11s and things like that. But bankruptcy is something that sometimes figures into this. Fair Debt Collection Practices Act, FDCPA, sometimes factors in. Are they if it's a home, if it was a lien for personal family household types of debts, Fair Debt Collection Practice may come in. And final note I wanted to make here is UFTA. Do you see this? UFTA. I don't know how you say. Uniform Fraudulent Transfer Act, okay? So this is a law that prevents fraudulent transfers, because what's going to happen here is the judgment debtor is going to say, oh, geez, they're going to get a judgment. I better quick sell my house. I better quick transfer all my assets. I better hide my jewelry. I better give away my art or give it to my brother or something. I have here bogus liens. Here's another strategy. It's like, I got a house. Can you call your friend? Let's do a lien. Let's say I owe you $500,000. Let's say I owe you $500,000. I'll put a lien on the property. Put a lien on there so it's all encumbered. Consensual foreclosures. Well, go ahead and foreclose on me. Something like that. And just fraudulent transfers that have sham consideration. I transferred it for my jewelry, my pearl necklace for $200. Oh, wow. neat. Yeah, I got rid of my Hatteras yacht for $5,000. Yeah, oh, okay. So if there's fraudulent transfers, they can be undone. It's a whole other area. But I wanted you just to see the general landscape of enforcing judgments, getting judgments. A lot of what I talk about on my other videos and what happens when there is a judgment. Now you may say, well, I have nothing now. Again, if they renew, it says up here renewable, it's not renewable energy, but it's renewable judgment. You may not have money now, but maybe 5-10 years from now you do. So again, before you default, this is some things to consider. I hope you enjoyed this. General legal information only. I also want to thank you all. I hit 35,000 subscribers. It's taken me several years to do it. I want to thank all you people that have been watching, commenting. You give me great comments, supporting us. So thank you for watching. As always, if you enjoy this video, feel free to share it on your social media networks. But thank you for watching. Have a great Sunday, and I hope this has been helpful for you. Gotta run. Bye now.